You sued your doctor claiming that he was careless, causing you significant harm and injury. And now you learn that during the course of your lawsuit, you will have to answer questions by the attorney who represents the doctor whom you have sued, known as a deposition. Let me share with you in this quick video exactly what you should never do during the course of this deposition. Come join me as I answer that question and explain to you how these types of cases work in New York. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so now you believe that your doctor was careless and caused you significant harm and injury. A medical expert has confirmed that yes, your doctor was careless, yes, his carelessness was a cause of your injury, and yes, your injuries are significant and permanent. And now your attorney tells you that during the course of your lawsuit, you will have to answer questions by the attorney who represents the doctor whom you have sued. Lawyers call this a deposition. It's also known as an examination before trial. So now in the months leading up to your deposition, your questioning, you're imagining in your own mind everything you're going to tell this attorney. You can't wait to sit down in your attorney's conference room and to tell him every single thing that happened. You can't wait to tell him every single detail that you know happened in this case. And now, the day before you are set to be questioned, your attorney now calls you into the office and he tells you, here are the questions you are likely going to be asked. And then he tells you something that totally blows you out of the water. Your attorney says, you have to pay close attention to the question you are asked. And you say, okay, that's fine. And then your attorney says, no, you have to pay close attention because you are there to only answer the attorney's question. And you're like, what do you mean? I thought I'm there to go ahead and tell my story, to tell everything that happened. And your attorney, if he's smart, is going to turn around and tell you, no. The deposition is not your opportunity to tell the opposing lawyer every single thing that happened. It is not your chance to tell him everything that happened, everything that you remember happening. Instead, a deposition is simply an opportunity for you to answer the questions put to you by the defense lawyer. That's it. If the attorney asks you, what's the color of the sky? Don't tell him about the 10 minutes it took you to get to the place that you finally observed the color of the sky. Okay? Answer only the question that you are asked. If the attorney asks you what happened next, then tell him what happened next. Don't tell him about the things that led up to that. Why? Because he hasn't asked for it. Don't tell him about the tangential things that he didn't ask for. Pay close attention to the question that you are asked, and your deposition will go a lot smoother, and you will be a lot happier, your attorney will be a lot happier. If the opposing attorney fails to ask important questions, that's his problem. That's not your problem. It's not your attorney's problem. You are there to answer only the questions that you are asked. So when the opposing attorney asks you a very specific question, answer only that question. Do not give an explanation. Except, there are always exceptions. Every time you talk to a lawyer, there's always an exception. Okay, and here's the exception. When the attorney now turns around and asks you about your current problems, about things you can and cannot do, now, here comes the exception. Now is the time that you should be talking. Now is the time you should be explaining. Remember, this opposing attorney doesn't know you. They only know what's in front of them in the papers that they've obtained. They don't know what you go through every single day. They're not there with you at home. They don't see the pain you have doing your daily activities. Now is the time for you to go ahead and explain. But when it comes time to talking about conversations, when it's time to go ahead and explain the events leading up to the wrongdoing and events that took place afterwards, focus only on the question being asked. And if you do that, you will have a much better experience than if you don't pay attention and instead try and tell your whole story thinking that the defense lawyer wants all that information. So why do I share this quick information with you? I share it with you because I have a few minutes to spare, and I thought you'd find this interesting and fascinating. Hopefully it opens your eyes to what really happens in a deposition, in a medical malpractice case, where the defense attorney gets to ask you questions, and now it's time for you to answer them. I realize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. Have a wonderful day.